My name is Mike Oken, and I'm General Counsel to the North Carolina State AFL-CIO. I'd like to very briefly give my take on the constitutional amendment that deals with filling judicial vacancies. In our state, we elect our judges. Under our Constitution, when a vacancy occurs, the governor fills that vacancy, but that person must run in the very next election so that people can decide. The Republican-dominated legislature has proposed a very confusing amendment to give it power in place of the governor. Under this amendment, a commission that includes legislatures will nominate a number of candidates to fill vacancies. Then the legislature, and the legislature alone, would send two names to the governor, and the governor must pick one of those two names. Thus, the legislature will effectively be picking who will fill judicial vacancies. And under this amendment, those judges who are effectively appointed by the legislature will not have to run as now in the very next election, but in the election after the next election, so that judges may have up to 4 years before the citizens of the state get to vote on them. Then there is this. Currently, the North Carolina Supreme Court is 5 Democrats and 4 Republicans. Only one seat is up this year's election, an incumbent Republican. If she wins, it will still be 5-4 with a Democratic majority. The strong belief is that if this occurs, then the legislature will have a session in which it creates 2 new seats, appoints Republicans who will not have to run for 3 or 4 years, and the Republicans will thus have a majority in 2020 when the next round of gerrymandering cases comes around. When the amendment was being debated, there was a proposal to make sure that that couldn't happen, but the legislature voted it down. It is worth noting that on this amendment, every former Chief Judge of the Supreme Court who's living has opposed it, and every living governor has opposed it. It is a pure and simple power grab, and one that is not good for the judiciary.